We'll try to run a fast and lively discussion here on this question of case selection in international justice, and particularly at the ICC. We have a panel of three people who are quite expert in this area. As was pointed out by Bill in the last session, we've got great biographies, so I won't go into extensive introductions of each. I did want to start the discussion by just a few comments from my own experience. I remember speaking on this topic several years ago, and Bill got up and says, yes, this whole business of case selection, this is really terra incognita. We don't know how these decisions are made. And it's now become a subject of, I think, much more academic discussion. And I know that Meg wrote an article recently on how choosing to prosecute. And this whole question, when we see how relatively few cases are actually prosecuted, and the many that aren't, it really does raise questions about that decision-making process and how that fits with the goals and norms that we're trying to enforce through international justice. I came to this process from a national system, from federal court, like Jack Smith, who's now the new prosecutor at the Kosovo Specialist Chambers. And we were quite used to the idea that we only selected a few cases. Now, of course, we had the benefit of being in a system where the local prosecutors prosecuted a great many and we could be selective. But I remember we were told by the U.S. Department of Justice, only prosecute one tax fraud case a year and prosecute it right around tax filing deadline and make sure it's a good, strong case. And it gets a lot of publicity. And so we sort of lived by the idea that we wanted to have impact by our prosecutions. On the other hand, when we go to the international level, we find people that have been involved in systems where there's really a duty to prosecute. I think we heard that from Mr. Dickert this morning, where someone who was describing the federal German law on war crimes and crimes against humanity. There's discretion if you're going to go into these UJ cases, but when it comes to someone that committed their crime in Germany or is a German, there's a duty to prosecute. And it reminds me of a discussion that we had in our sort of group of international prosecutors at one of our annual colloquia in 2006, when Luis Moreno Ocampo was talking about all the ways that he used discretion and how he was impacting the world by casting his shadow. And that caused Carla Del Ponte to respond, discretion, discretion, what is this discretion? I prosecute guilty people. And indeed, her approach is, some guilty people, let's prosecute them and let's just keep going and prosecute as many as we could. And I faced that at the ICTR, and I might mention that in just a moment. But before I go there, we saw Ben Ferenz this morning, and I think many of you heard that he's in good shape now, but he had open heart surgery yesterday or the day before in Chicago, had 4 stents put in. And I've got a nice picture of him smiling and wishing us well. So he's bouncing back, and we I think really looking forward to seeing him again soon. But if you've seen this film, and it was shown in The Hague at the time when we dedicated the bench Ferenz at the Peace Palace. But it's now out. There were 1,000 people, an oversold crowd for it last week in New York, and hopefully it'll soon be on Amazon Prime. But it's Prosecuting Evil, the story of Ben Ferenz, and in it he describes, how he answered the questions of case selection, which is kind of like which crime scene, who do you prosecute, and how many, and of course on the which he had. As you've heard this story many times, I've been supporting other trials and had come here to Berlin, and his team had found the records of the Einsatzgruppen. And he brought along an adding machine and started adding up the numbers of killed Jews and others at these various killing sites in Western Russia that followed the Wehrmacht, as the Einsatzgruppen followed the Wehrmacht after the invasion. And adding them up, and they were very precise numbers from places like Babi Yar and elsewhere. And when he got to 1 million dead, he went to Telford Taylor and said, "I've got to do this. We've got to do this." And as you know the story, we don't have time. We don't have a prosecutor. I'll do it. He did it. He led this greatest murder trial in history. And of course, clearly that scene, that crime, that greatest murder trial, certainly an example of gravity, such an enormous crowd and by these distinct units. Then he was asking the question of who to prosecute, and this is a bit humorous. Well, one, he said, and this is what all courts have to confront, who do we have? I'm not going to go chasing after and trying to arrest somebody. And we got plenty of guys that are being detained that were involved in these units, so I need to pick from that group. And I think we always see in these courts, and we saw with the selection of the first cases in the tribunals and in the ICC, is who could they get in custody quickly to move forward on. And that's always a major factor, but clearly that was not a big challenge in terms of finding the right people at Nuremberg. But then he said, looking at all those that were involved in these squads, he said he only went after officers. He'd been an enlisted man. Enlisted man always had to, weren't really responsible. So those dang officers would be the ones, and the highest level ones that he could get as well. And then those that had PhDs. He really wanted to focus, and indeed I think Oldendorf has 2 PhDs, the leading defendant who led the Eisetz group and then was of course hanged in 1951, and Ben in this movie describes his last conversation with Oldendorf just before his hanging. But in any case, it was these high-level individuals who really were in a position to know better, who really did make decisions about where they were going to go and what they were going to do, where others didn't. Reminded me of the discussion we had yesterday in Paris, where Eric Emereau, who leads the French gendarmerie unit that supports the French pole for the prosecution in these cases, who'd worked at the ICTY and Sarajevo, et cetera, said he understood very early on that people didn't want to kill their neighbors, but they were pushed into that by soulless individuals, by leaders in support of those leaders' own authority and power and wealth. So going after those folks made sense to Ben. And finally, there was the question of how many. And he didn't say this in the film, but others have said it before. And as you all know, when it came to the great trial of the IMT and the 12 subsequent provisions, there was one hard and fast, indeed a wooden rule, and that was that on the benches there were room for 22 people. And so every one of the cases involved 22 defendants. And Heinrich can show you the bench upstairs, which was in the cellar here, I think, for 40 years, and show you if you can get 22 people on those benches. I don't know if it's all of them, but in any case, that was the main limiting factor. The other thing I was going to say is, I was later prosecutor of the Special Court for Sierra Leone, like Serge. I came on after initial decisions had been made about who to prosecute. But the real time that I think a lot of us, that I know those of us at the ICTR got involved in this issue and ended up heading up the process, was in 2003. And it was just after finishing the media trial under the presidency of Navi Pillay. Carla had lost the portfolio of Arusha and had become solely the ICTY prosecutor. Hassan Jallo had come on. And then in September of 2003, the Security Council passed Resolution 1503, mandating this completion strategy, calling on us to basically finish our investigations by 2004, indict everybody by 2005. And at that point, we had 160 people on our GAMA list, which is a list of additional people to go after the 80 or 90 or so that we'd already charged. And I know even during the media trial, I could never get any investigation on an ongoing basis because people were busy building these new cases. But we had to deal with that, and we formed a committee, and we started going through these files, and eventually we whittled the 160 down to 16, and it's finally my task to limit it down to 8, and we got down to 8 individuals, and a key factor there was the strength of the case, the ability to get the person, the level of the offender, whether there were territories or themes that we hadn't covered, and then because we've been mandated by the Security Council to look at other jurisdictions, cases like the 2 in France, which they one of which they haven't moved on yet, or in Rwanda, cases that could be done elsewhere. Those were cases that we clearly should set aside. Anyway, that's my own experience here, but I know as we deal with this issue, it really is an essential one, and as we give the speeches about how this International Criminal Court, the court of last resort, but still should have all this impact, how is it that these defendants in particular are picked, and indeed the sort of which question, the situation, the crime scenes as well, goes into that choice case. But let me turn now to the first member of our panel, Serge Rammertz, who's you can read his biography, but for now almost 11 years, he's been the prosecutor of the ICTY, and a couple years ago took over the MICT, or the International Mechanism for the Tribunals, that includes the ICTR cases. And he had to deal with the business of concluding these trials, and from the point of view of having to deal with these cases in court and bring the ship to shore, I'm interested in what your sort of top lessons are, or even your top 3 lessons for case selection, and whether and how you think it was done and could have been done differently.
Thank you very much. Good afternoon, everyone. Definitely for all international prosecutors or colleagues involved in international prosecutions, case selection is probably the most difficult and the most frustrating exercise. I've been in charge of a Belgian prosecution office in Brussels, and there's no question about prosecuting all crimes. You have a mandate to be comprehensive in approaching crimes, and you have just some priorities going as priority after certain categories of crimes, very much determined by the College of Prosecutor Generals or by the Parliament. But basically, all crimes will be investigated in prosecutors, especially if they are of a certain gravity. And there's no doubt that all the crimes which are investigated internationally would be the top #1 crime in individual jurisdictions. I don't think there are any very 100% clear criteria based on which case selection is done, and we had similar discussions in the past in the same forum. So perhaps 3 elements in this regard. I remember when I took over in 2008 at ICTY, there was already the criticism out there saying, well, the tribunal has prosecuted lower and mid-level perpetrators, should have gone for the big guys, this was a waste of resources, etc. I think if we're looking back, a large majority in our office is of the opinion that it was at the end of the day a good experience, especially for new institution, to test the rules, to test the waters. It's important to start somewhere. And especially if you have a tribunal like the ICTY or ICR, especially ICTY, which has been in existence for so many years, starting with a number of low-level perpetrators allowed the Office of the Prosecutor to gather a lot of evidence in relation to higher responsible. You could have and find insider witnesses. And for example, with Karadzic, Mladic and other trials who took place very, very late, well, by having prosecuted their left hands and right hands, I think we had much stronger cases thanks to the prosecution of lower and mid-level perpetrators. So all this discussion about top-down, bottom-up, I think it's an important one, and I think there are good reasons to work on both, especially at the beginning of an organization, knowing that at the end of the day, the objective is to go after the top leaders. But if prosecuting mid-level perpetrators ultimately allows you to have a stronger case against the top leaders, I think then it can really be justified. Scope of indictments, it was mentioned before. One of the issues we were confronted with at the ICTY was that indictments were very, very large. I mean, it has also been said 100 times that, for the Milosevic trial, the indictment was too broad. That's one of the reasons why he died, perhaps before the end of the procedures. Well, there also, it is an extremely tricky exercise to make this kind of selection of cases where you know very well that there is a likelihood that those cases you are not prosecuting will never be prosecuted, and those victims will never see justice. What we have seen over the years at the ICTY was very much that we reduced on a voluntary basis the scope of the indictment. We have discussed it also in the past when when Karadzic was arrested, and even more so when Mladic was arrested, also based on his poor health, as you remember. Well, we had to decide how to deal with the indictment, where there were 400 witnesses foreseen, crimes in many municipalities which were part of the indictment, where we had to take this decision on a voluntary base to reduce the scope of the indictment. We had many meetings with victims' organizations to try to convince them that it was necessary to do so, and we were very much impressed that victims' organizations at the end of the day were on board in reducing the indictment. And at the end of the day, we reduced, had more than 25 municipalities where crimes had been committed. We reduced them to a little dozen, because if you can show, of course, the widespread and systematic nature, it is sufficient to prove it in a limited number of cases, and then selecting based on, of course, gravity of crimes and number of and evidence available, but also in relation to evidence available. We all know that a prosecutor has tendency also sometimes, to give, to go stronger for a case where you have strong evidence and a direct linkage evidence than for another case where you have perhaps a higher number of victims, but where you have little evidence. And this is definitely something, also for the discussion. I remember the very first days at the ICC, it was very much the opposite approach, by saying we go for very, very focused investigation. So one could, in a little bit simplistic way, say that in the early days, the ICTY perhaps went too broad by trying to cover everything. But one could perhaps argue that the ICC in the early days, and it was changed later on by Fatou Bensouda, perhaps that the early days went too small, with perhaps a too limited number of incidents, with a too limited number of witnesses, which creates another risk of witness interference and evidence to be confirmed in the courtroom. And the last element, timing. We all have learned at university that justice delayed is justice denied. Well, I think this has to be seen very, very differently in the international context. Someone who cannot be prosecuted today, well, perhaps 5 years, 10 years down the road, it is possible. We have seen it with the ad hoc tribunals, Karadzic, Mladic, as we all know, in the first years after they were under international arrest warrants. They were still driving around with escort and close protection. Well, it took 13 years, 18 years to get them arrested. But at the end of the day, time plays in favor of justice. So I think that another factor which really has been important has been time. But I will stop here as my short introduction.
But let me just follow up in terms of this question about who you can get. Obviously, the ICTY we always cite was able in the end to bring all 161 people in one way or another. Some cases were transferred or closed, but in the end that arrest list was completed. And I know a concern at the ICC is the 15 unanswered arrest warrants and cases like Bashir's that have now been out there 10 years or Coney longer. And just in terms of if the goal here is to take out certain responsible, those bearing the greatest responsibility or the most notorious or whoever they are, and one's not looking at this question of who you can get, what kind of lessons do you think you learned? Obviously, you went after some people, Milosevic, Karadzic, Mladic, that were going to be very hard to get, but got them. And so what's needed so much is an effective strategy for that.
Well, yes. We like to say, as colleagues at the ICTY, well, we are the only international tribunal with no fugitives at large. We closed with mission accomplished. It's of course a little bit too easy answer. We know that the political context was very different. I think when in the 90s ICTY had been put up, there was a much stronger willingness to see international justice succeeding than today. I think that's unfortunate reality. But then we have seen that there has been a very strong political support from outside, from the US, support we are still having until today, but also in relation to the European Union. And we have said it many times before, conditionality policy has been an extremely important tool to convince countries to cooperate. It was very, very clear. Brussels gave a clear message to Croatia, to Serbia, to Bosnia. Well, you want to join the European family? Well, there are a number of conditions to be fulfilled. One of those conditions is the arrest of the fugitives. And I remember in 2008 when we started, there were surveys in Serbia done by international organizations where 60% of the population were against the arrest of Karadzic and Mladic, And to have a majority of politicians who would do something against the will of the majority of people, I think there are a few countries where a government would do so. But there were 75% of people in favor of joining the European Union. So it was, I think, a very much political calculation. There was more to be gained by, at the end of the day, having the fugitives arrested. And so I think that one of the very important reasons why we have been successful, in addition to having, I think, a quite good tracking team, working very well with international police organizations, etc. So in addition to working well on the operational level, I think that the political support was crucial. And again, if the ICC is not in the same situation, it's because there's nothing like an international community supporting unanimously the ICC to be successful. You have those very different opinions out there, which very often are counterproductive. And it is obvious that the success of the ICC in terms of arrests will, to 95%, depend on the willingness of the international community, meaning countries and their police and military forces, to do their job by arresting the fugitives.
And just a final question. I mean, you've talked before about your relationship with the prosecutions in the region, the state court in Bosnia, its war crimes chamber, the work being done in Serbia and Croatia and in Kosovo. And obviously, in the context of the ICC, we have this concept of complementarity, which some have seen kind of as an either-or. Either the state has the capacity and will, or it doesn't. And if it doesn't, you take it to the international level. But obviously, even at the ICC, we've seen situations like the DRC, where they've had more defendants than, certainly more defendants in court than in any other situation. But at the national level, in the military courts, they've convicted over 100 people in cases of sexual violence and other things. How those cases are selected, challenging. But now in CAR, we have a special criminal court, even at the same time that the ICC has jurisdiction in its second CAR, Central African Republic case. We'll probably soon see arrest warrants in that. At the same time, we've got this court operating. I mean, what lessons do you see in this business of sort of selecting, working with the national system, so the cases that you don't prosecute, they prosecute, and that you help them do that, the cooperative approach. I think the example in the Balkans is often cited, but how has that been able to work?
Well, I think one of the lessons learned from all tribunals, and for all situations, I think I can speak for the ICC as well. Well, we have worked for 25 years on one situation, 161 indictments, which is more than all the other international tribunals together. But next week I will be in Sarajevo, and there are 3,500 investigations ongoing, 500 cases against mixed and higher level perpetrators. So there will be cases ongoing for the next 20, 30 years. So one lesson is obvious. International justice, international tribunals, hybrid tribunals will never ever be able to address alone the magnitude of crimes which have been committed. And the question is really, when can you move from a sole international approach, move to a transitional phase, and perhaps to a local ownership? Well, it has taken very long for the ICTY. I think the first 10 years cooperation was very, very difficult. Many of the people under investigations were still in power. A lot of external pressure was necessary. And it was only once we were forced to implement the completion strategy that we really started cooperating extensively. And it's quite interesting to see, again, also from a historical perspective, that where the ICC obviously has complementarity in the center of its mandate, priority given to national authorities, well, for us it has always been the other way around, with primacy over national jurisdictions, and could really select our cases. But what we have seen for the last 10 years, basically, once regime changed, once legislation were adopted, and thanks to the completion strategy that we started transferring a number of, quite important number of cases. We will, by the way, transfer a few dozens of additional cases in the months to come. And we are getting today, which we moved, now that the ICTY is closed, we moved really from a driver's seat approach to a back seat approach. We are receiving still more than 200 requests for assistance every year. We still have, we had for the last 8 years, but we still have liaison prosecutors from Serbia, Croatia, Bosnia sitting physically at our offices. They take every year more than 100,000 pages of documents out of our databases to be used in national proceedings. We have a database of 9 million pages of documents. Also very much a difference between ICC and our tribunal. You know, we collected entire military collections by doing a number of searches. So we have the largest database in relation to crimes committed in the former Yugoslavia, and of course, this is a main source of information for colleagues from the region. So we have really seen that trying to get as soon as possible an integrated approach, because we all agree, I presume, that best justice is best served if it is delivered close to the communities affected, victims, but also perpetrators' community, in the language they understand, in the legal system they understand. Because what we see still today, or even today, even more than a few years ago, this total denial and glorification of war criminals in the former Yugoslavia, where it's still so easy to say, well, this is justice coming from The Hague, this is far away, we have nothing to do with it. So, international approach where necessary, going local every time it's possible.
Well, thank you for those comments. Let's turn to Meg now. As I said earlier, she's written academically and is working on a book also, but an article on choosing to prosecute. And from more the I don't want to call it theoretical point of view, but from the point of view of what the system purports to be and how it through its policies and practices implements these norms that you see as important. I wanted you to have a chance to discuss that, but I'd like to first turn to this question of situation, because we, obviously, Nuremberg here was dealing with the Nazis wherever they were doing their crimes, so they determined that it was only the crimes that were committed outside Germany that were subject to the jurisdiction of this court. But how the choice of situations, which obviously the prosecutor has these preliminary examinations, there's some point when she moves, like she has on Afghanistan, or Georgia, to seeking an investigation, others that may never come or may be closed. In terms of the policies that you see implemented at the ICC, how are they fulfilling what you think are the appropriate norms for international justice?
Thank you, Stephen, and thank you to the organizers for including me in this very important conversation. I think that the work of the ICC is more important than ever in this era of retranchement of globalism around the world, because it stands for, I think, the importance of globalism and multilateralism. And so even as it is increasingly challenged in its work, I think its work is more important than ever. So I applaud the Institute for Organizing, the Academy for organizing these conversations. I also want to emphasize that as an academic who has not been a prosecutor, I come at this from a very sort of intellectual perspective, and that I hope that I can contribute some interesting ideas that may be useful to those on the ground, like Fabrizio and Paquiso, who are actually implementing these ideas. But I also want to give that caveat that, having not worked in the trenches, the ideas are only so useful as they can be implemented. So in terms of situation selection, I think that it's important to recognize that unlike national courts, in particular national courts where prosecution of grave crimes is actually mandatory, which is not the case in my system, but is in some other systems, that the selection of situations by the ICC is a matter of identity. It is an important part of what forms the identity of the court, and therefore it is critical to think about situation selection in terms of goals, in terms of what is the purpose of this institution. And I think that's something that we have had, we as a community of supporters of the ICC have had insufficient discussions around. I was a legal advisor to the Senegalese delegation in Rome, and certainly my recollection of the activities in Rome, and those on the earlier panel who did an excellent job of describing the sausage making can disagree, but it was focused on the components of sausage, not on sort of the overall glories of sausages, or sort of what is the relative merit of one kind of sausage versus another. And so I think we just still haven't had those discussions yet about big questions around the purpose of the ICC, and that makes it difficult. Makes it difficult to figure out what criterion ought to guide situation selection. So with all of that being said, let me suggest a little bit of a critique of the ICC's current approach, and I'm sure I'll get some pushback from those more in the trenches. And that is to say that the ICC has, and I think very understandably, the Office of the Prosecutor would like to be perceived as simply following the law, objectively, impartially, transparently. And therefore, if you take a look at the policy paper on preliminary examinations, the OTP policy takes a very legalistic approach to the criterion of Article 53, and the idea that the office is required to investigate when there is a reasonable basis to do so, or unless there is no reasonable basis to do so, and that must be decided on the basis of admissibility and the components being complementarity and gravity, and then interests of justice. Then if you look at the policy on interests of justice, it's also a very narrow approach, I would say, to interests of justice, saying in particular it doesn't include interests of peace. So I think that the prosecutor has, to some extent, the office has tied its hands in order to appear as objective, impartial, legalistic as possible. And in the context of an institution where the parties setting it up were divided, although certainly a majority wanted an independent prosecutor, there was an important minority that didn't. I think this impulse to tie the office's hands is an understandable one. But I think that it detracts from the ability to have important discussions about, again, identity and goals. If there's this claim, well, we are just following the law. And what I'm writing about right now, and I have been writing about for a while, is this idea of gravity as the primary consideration in both selecting situations and then selecting cases within situations. The OTP says, well, we have these criteria for gravity and we follow them legalistically. And I think that that's not actually possible. I think that gravity is such a malleable concept that virtually any decision can be justified simply by emphasizing a different aspect of gravity, right? So if the number of victims is not particularly large, you can emphasize the nature of the crimes, or if the impact is not particularly impressive, you can emphasize the sort of more, the broader, right? If the direct impact isn't so strong, you can emphasize the broader impact and so on. And so I think this results in, detracts from our having a greater conversation about what are the goals. One thought that I want to suggest in this regard, and then I'll give the floor back to the chairman, is that I think there's disagreement about whether the ICC ought to be focused more on global goals, and in particular I have in mind here the expression of global norms. And I was happy to hear the prosecutor this morning emphasizing that aspect of her role, and I think in the policy paper on case selection there's also an emphasis on global norm expression that I think is laudable. But on the other hand, there is a pull at the court to focus on victims and to focus, in a sense, on the court serving as a surrogate for national criminal justice systems that are currently non-functional or unwilling or unable to function. And there's a tension there sometimes between the court selecting situations that will best express the most important global norms and selecting situations and cases that will most address the needs of the greatest number of victims on the ground. And I think that tension is one that deserves greater attention, and that the prosecutor would be in a better position to negotiate that tension by embracing discretion more fully, by embracing discretion at the situation selection stage and at the case selection stage. And to preempt the pushback that I'm sure I will be getting shortly from Fabrizio, I want to suggest one way that the prosecutor could embrace greater discretion at the situation stage would be to take a broader interpretation of the interests of justice, right? So I think that the gravity threshold ought to be a very minimal kind of a threshold, because otherwise one reads into that something that becomes almost akin to a limitation on jurisdiction. And I think that's the debate between the judges internally in the Comoros situation and between the judges and the prosecutor bring that to the fore, that if gravity as a threshold for admissibility is imbued with particular characteristics, numbers of victims or particular kinds of crimes, particular levels of responsibility, it becomes akin to a limit on the court's jurisdiction. And that precludes the court from potentially benefiting lots of different types of situations. On the other hand, if the gravity threshold is kept at a minimum, and there's also the ability to have gravity as a discretionary selection criteria also for situations, not just for cases, and that can be done in the context, I think, of the interests of justice provision, thinking of the interests of justice as sort of interests of global justice, not necessarily just in one particular situation, that would afford the prosecutor more ability to help make the court the instrument of global justice that I think it ought to be.
Let me just follow that up, Meg, because I'm thinking about the critique on this gravity issue. I mean, we can certainly envision a situation where a particular country might have some guys under arrest and good cases against them, but to try them locally would cause all sorts of division or political problems. So they say, ICC, would you take this case? We really don't have the capacity to do it. And there may be 300 dead or something like that, and the ICC takes it and may succeed. Where a few countries over, there's 30,000 people dead, but the local leader has all sorts of political support on a global basis, et cetera, and you can't get anywhere. And so you might say, well, let's not move on that one. You know, you talk about enforcing these global norms, the outsider, the victim, certainly in the situation where there were 30,000 victims, would say, this is political. Our leader has enemies, but the leader in the other country has a friend in The Hague. And that's why we're making a decision. Doesn't this kind of opening and making it more flexible, albeit perhaps getting the courts some better conviction rates and things like that, isn't it going to make the court subject to even more criticism, like it was, for instance, when it took on the first case on the LRA and sort of embraced Museveni's referral, implying that there wouldn't be any prosecutions on that side?
Right. So I think this is the role of politics discussion, and I think that the word politics tends to send shivers of fear down the spines of most prosecutors, whereas academics are much more comfortable with politics being acknowledged as part of process, right? And so I think it's difficult to answer the question, which would best promote the legitimacy of the court? The prosecutor being more transparent about the role that politics actually play in decisions, because I think many people would acknowledge that despite what prosecutors tend to say about politics playing no role in their decision, at least international prosecutors saying about politics playing little or no role in their decision, that's not actually true, that there is some role being played behind the scenes, or embracing that and being more forthcoming about the role that is being played, and therefore potentially engaging in that process more fully. In other words, for example, if the prosecutor feels that the Security Council referral is not being backed up politically, is not being backed up with proper support politically, being vocal about that as part of the decision, well, it's not in the interest of justice to do this because we don't have the political support that we need to do it. Would that be better for the ICC's legitimacy? I think maybe, than just having it be kind of a shadow part of the process.
Well, let's get down from the situation into the actual case selection, and I guess that involves both the sort of which scenes in situations are end up being prosecuted and who is prosecuted. The OTP put out this statement, in fact their policy a couple years ago. I remember being called because I got several press calls saying they're going to prosecute environmental crime, but in fact there was a small provision that said that this could be a factor considered in terms of environmental impact for prosecuting the crimes clearly under the statute. But we heard the prosecutor this morning talk more about, to some extent, going after notorious mid-level individuals, et cetera, not necessarily going straight to the top. What, in terms of your own analysis and reinforcing and strengthening these norms for compliance with international criminal law, how do you evaluate that policy and its implementation so far?
Yeah, I think that ICC has actually done a very good job of selecting cases that will promote important international norms. So selecting cases that involve under-prosecuted crimes, like the recruitment and use of child soldiers, like gender-based violence crimes. I think the policy paper on case selection reflects that. The insertion of the emphasis on crimes that cause serious impact on the environment, crimes that instill terror, even though terrorism is not a crime, the court can select, or the prosecutor can select cases that involve crimes within the court's jurisdiction that involve the installation of terror in the population and so on. I think that is precisely the right way to go about this. Because again, this is about the court's mission in the world, the court's role in the world. And I think that's the way that the court can have the greatest impact, is by embracing this global norm proliferation mission, as opposed to, for example, going into one situation and trying to prosecute the sorts of numbers of crimes that might give some satisfaction to the many, many victims in the situation, right? So the court could say, well, we're just going to take one situation at a time, and we're going to stand in for the local justice system that's non-functional and just try to prosecute as many mid-level and upper-level people as we can, and then we won't move on from that until we've done something good there. And I think that would be a mistake. I think that taking this broader-based approach of having an impact via selecting cases that make a statement about the kinds of things that the global community is not willing to tolerate, I think it's basically the right approach. I think, again, the prosecutor doesn't embrace her discretion quite as much as I would have, and tries to make gravity appear more objective than I think it actually can. But I think the actual practice is one that supports the vision that I have for the court.
Thank you, Meg. Let me turn now to Richard Dicker, who's been with Human Rights Watch, I think, since 1990, and has been in charge of their international justice program since 2001. So he's been present all through and engaged all through the ICC's active life, and certainly that of other courts as well. Richard, you've watched it, you've commented on it, you've participated in your role at Human Rights Watch as an observer and an advocate. How do you evaluate the case, the situation and case selection practice of the ICC since the beginning? And then I'll ask you another question about what could be done better if it's not been done perfectly. But let me ask you the first question of how you evaluate it.
Okay, well, Stephen, from our perspective, the decision on case selection, who to charge and what crimes to charge them with, is of singular importance. And the ramifications of that decision have such spillover effects. And I want to try to enumerate a few of those effects. I want to try to make some constructively critical comments on case selection and highlight a couple of recommendations around your upcoming question. But before I do that, I do have to take a brief digression, first and foremost, to thank Klaus Rakowitz and Vivian Dietrich and the staff of the Nuremberg Academy for all the work they put into this. And just to say, when they came up with this idea a year or so ago, no one would have thought it could be as timely as it is today. So thank you for that. And my second digression is just to amplify on a point that Meg made in her opening and that the German foreign minister made, I thought, very clearly in his remarks. And that is, the court, as we are all aware, is functioning in a different and much more difficult international environment than it was when we stumbled out of the Food and Agricultural Organization in the early hours of July 18th, 1998. And I don't need to enumerate for you what's different. What's concerning, of course, is the diminishing respect for multilateralism, for a rules-based international order, and for respect for basic international humanitarian law and human rights provisions, as indicated, I believe, as the foreign minister said, in the use of chemical weapons, as indicated as recently as last month by not just John Bolton's comments, but let me draw your attention to the comments of the President of the United States when he opened the General Assembly on September 25th, where he took his vitriolic swipe at the ICC. So all that's the context. And in that context, I think the stakes are higher, and that means for all of us, and in that I include states parties, I mean civil society, and I mean court officials, and we're talking about court practice, so I will come to that. But I think all of us need to reevaluate, rethink our commitment to the ideal that brought us to Rome and led to the completion of the treaty. If we don't do that, I fear we will not succeed. Now, as we're dealing with the issue of case selection, I just want to say to Office of the Prosecutor representatives, senior officers in the room today, that my organization, implore you to draw on lessons learned, to work in the smartest way possible so as to rise to the challenge that is demanded of this institution today. And it's in that context, on case selection, I want to say, and Stephen, interrupt me whenever you want.
I wouldn't do that.
No.
I'm from Iowa.
Well, I'm from New York. In any case, the effect, the spillover effect of the case selection decision runs first and foremost to the communities affected by the crimes and whether the proceedings and developments at the ICC will be accessible and meaningful. That is a huge burden for the Office of the Prosecutor to bear. The selection of cases sets the framework for within which other organs of the court will play their role, specifically the registry. And it's not only in the communities most affected by the crimes that the selection of cases is important, but it will bear on the perception and the legitimacy of the court in the international community. It affects a broader perception of the court. So those are some of the consequences, and there are more. Now, in that context, in 15 years practice, we've seen missteps in case selection, and I want to add that we think with the publication in 2016 of the case selection policy, we have seen real improvements. So I want to acknowledge the improvements up front, but I also want to say in the company of court supporters and friends, a couple of things that we have drawn from practice. One, the failing to bring cases where more than one party is involved in an armed conflict and more than one party has committed serious crimes to both sides or all sides of that conflict. I'm thinking of decisions made in the DRC, in the Kivus in the east. A long ago decision failing to establish individual criminal responsibility at senior levels of leadership. We think that's been a real concern, and failing to minimize the time lag between cases against different parties to the conflict. I'm thinking of Côte d'Ivoire. There are others I'm glad to go into, not in taking pot shots at the office, but to suggest what causes us concern. Finally, we recognize that case selection decisions are as challenging as they are important, if not more so, especially in situations of ongoing criminality and where the evidence is evolving to support cases selected for prosecution with an evolving evidentiary base. The challenges only increase. So I'm glad to make a few recommendations, Chair, or not.
That, I mean, and I don't want to get too, well, I will get specific. You know, and you talk about not picking necessarily the right cases. Well, the Kivus, but obviously with cases out of Turi and Lubanga was the first one, and to some extent the lesson that a lot of us learned at the tribunals of cutting things down was reflected in the decision just to go after Lubanga on child soldiers, thinking that would be simple. Of course, the first case always turns into a meal. You can't just make it a snack. It's going to be a big thing. But there was a lot of criticism, as you recall. The victims groups wanted to add the sexual violence, and eventually the ICC chambers determined, no, this is a decision for the prosecutor alone, which we're dealing with here. But more recently, we had the Al-Faki Al-Mahdi case, which obviously someone that was already in custody in Niger, but was clearly prepared to confess to this attack on the tombs and the one monument. That case moved quickly, got lots of good comment in terms of establishing this norm in terms of cultural destruction, which is so important as we look at what ISIS is doing in Palmyra and that kind of thing. I mean, are those cases, is it appropriate for the court to take that kind of small approach, or should they have been saying, as some of the victims I know said in Timbuktu, no, Al-Faki Al-Mahdi, you could have built some sexual violence counts against him. And once he's pleaded guilty, you're not going to go after him on something else. So is it right for the court to do those arguably, I don't want to call them a snack, but a smaller bite kind of case in order to establish a norm? Or should they really be, going to the person with the most responsibility for those individuals' crimes, or building out what you could, through a full investigation, prove as to that individual's responsibility?
Well, I think that first, I'm not sure, and of course I'm on the outside, so I don't know much of the essential issue, which is what is in the evidentiary file. So I can't speak to that. I've long believed, and people will certainly feel free to correct me, but the child recruitment charges brought against Thomas Lubanga may not have been the original vision of what the charges would be against Mr. Lubanga, whose militia was responsible for a broader range of crimes. And I think that allows me to flag. I think that certainly the OTP deserves recognition and credit for really strengthening its investigative processes. So I would characterize the Lubanga charges as not flowing from a plan, but this is all they had and they went with it. I think a bit different with the Al-Mahdi case. I don't agree completely with Meg. In fact, I agree in part and disagree, in the sense that, yes, as was done in the Al-Mahdi case, the office gave expression to a much broader crime that has come into prominence. But I don't think its role in terms of case selection should be principally defined by bringing new norms or consolidating and defining new norms. I think case selection has to be determined by the factors of representativity of the crimes, the most serious crimes, and of course the evidence available. And in that dynamic, I think gravity, indeed, it's a broad term, but nonetheless, I think it's got to be the essential criterion.
Well, let me ask you about your suggestions for the future, and I know. I mean, one of our friends that's, I think, actually been published twice in the Times now, our friend Thierry Couvalier, who was doing a judicial newsletter when I was in Arusha, always very critical of what we were doing, but in, I thought, a constructive way, and someone who wanted us, in the end, to succeed. he's had a couple quite critical pieces in the New York Times about the court, but suggesting that the court should be looking to do sort of smaller cases that it can succeed on, human trafficking cases out of Libya or something along these lines. Do you think that should be the future of the court, or what do you think, just in terms of getting some, the perception that it's effective and that it can get people arrested and that it can get people convicted and that it's something to fear? Is that the approach, or is the approach building the strong cases against people that the court might have a considerable difficulty arresting?
Indeed, that is another tension that that is another tension that permeates the very, very difficult decision-making that the Office of the Prosecutor has to make. I think there needs to be, first and foremost, a vision in the office as to what the OTP is seeking to achieve in each and every one of its country situations. We think that the paper of 2016 was a terrific advance, and we welcome it. But we were struck that it lacked a sense of a more holistic vision as to what it is trying to accomplish in addressing accountability needs in specific situations. And I think our most principal recommendation is to, if it is not, and again, we are not privy and don't need to or want to be privy to the internal thinking at the office, but our first recommendation is to define a proactive vision for each country's situation, which frames the case selection decisions. In other words, the tough decisions on which cases, and managing that tension you're referencing here, Stephen, on the most senior or more mid-level. I mean, that's got to be framed by that overarching vision that includes this sense of what the OTP, through its work, is hoping the country situation will look like after it has completed its work. Specifically, I think there needs to be some of both. And I heard the prosecutor this morning speak to that. We welcome the decision to go after mid-level individuals. But we think that needs to be done on the basis of crimes that are representative of what the communities affected by those crimes have experienced. So I don't have a yes or a no answer, but what we do take away is the very limited number of cases the ICC is bringing in country situations. And a question that flows from our thinking is, will that be sufficient to address the accountability needs? I have questions about that. And I want to just end on the note of resources. I mean, come on, 11 situations with investigations. Serge, how many country situations, was the ICTY involved in, and their proximity? This is 11, well, they would say 4, Fabrizio, but I mean, the countries would. But 11 different country situations with the resources this court has, that the office has. And that comes to the point I was trying to reference earlier about states' parties and getting real about this institution. It cannot function without more diplomatic support, political support, cooperation support, but without more resources. And from what I can tell, some of the largest contributing state parties, and I was glad to hear the foreign minister welcome the referral of Venezuela. We hope that will translate into a recognition of increased funding for the institution. Otherwise, there's something very missing here, and that is frankness and honesty in terms of the commitment for this institution to succeed.
Before we go to a comment, and I know Fabrizio wanted to speak, but I'm intrigued by this idea of this prosecutor who sort of outlines what's intended in each situation. You've got a quite talkative, a prosecutor who's answering questions about where she's going, where he's going. Afghanistan gets approval in the pretrial chamber. Does the prosecutor call a press conference and say, I want to I want this case to involve, mistreatment and torture in custody, whether Afghani or U.S. or allied ISAF custody. I want it to deal with the crimes against civilians by the Taliban. That's what I'm looking for. I want to have a clear indication that in these kinds of conflicts and protracted situations facing a group like the Taliban or others, we want to have this kind of effect. Of course, the prosecutor's doing that having not opened the formal investigation yet. As a federal prosecutor in the U.S., we called a lot of press conferences, and some people, arrested their people on camera almost, and get criticism for being so public about cases. Right now, we have the model in the United States of Robert Mueller, who never says anything except in the indictments, and follows that kind of approach. Do you think it's appropriate that, this is Luis in his shadow, that by talking about things we have an impact, or shouldn't the prosecutor be speaking through court filings and through general policy documents? But you would seem to suggest the prosecutor should jump into describing what's going to happen in each situation, or what she or he would hope to see happen.
Well, I did want to suggest that the vision that I was talking about needs to be shared with us so much. Again, this is an independent office, and we respect that independence. States parties need to respect that independence. So we don't want information we don't need and we shouldn't have. That's an important clarification about my comment on vision. We hope the office has it, and to the extent it can, share some of it, but we don't expect it to lay out a blueprint of where it is going in Afghanistan or anywhere else. I think, however, there are limits to deterrence through words. I am glad when the prosecutor makes statements, as she recently did in regard to killings in Palestine. When was it? In June, I think it was. She made another statement about this is a country within her jurisdiction. I think those kinds of statements, well thought through and made on a timely basis, are important. However, nothing speaks louder than actual criminal charges. But unlike Robert Mueller, Fatou Bensouda does not have a police force that is going out and arresting indictees sought by Mr. Mueller. And again, that's where states parties come in, and they need to ramp up their assistance with the office in this matter.
Very much, Richard, and thanks to the panel. I think our I don't know what the wall clock means. It looks like we have 21 minutes or so left to our panel, if that's correct. We've said a lot about the ICC and the policy and the practice of the Office of the Prosecutor, and I know Fabrizio still wants to make a few comments and reaction. and as much time as you need, up to 21 minutes and 24 seconds. But we'd also like to have a little more discussion. And I did tell Mr. Toledo that I would make some summing up remarks at the end. But fire away, Fabrizio.
Thank you so much, and thanks to the panel for a terrific discussion. Perhaps I just three or four points perhaps worth clarifying or putting a bit on the theory back to the makers.
You can stand up so they can see behind.
Sorry? Yes. The first thing perhaps is, Meg, in relation to your vision of situation selection. I think it's important. Our previous panel was about the making of the Rome Statute. I think it is important to go back to Rome because in Rome, the discussion took place as to what type of discretion we were going to give the office of the prosecutor in terms of opening an investigation once the statutory criteria were met or were deemed to be met. Were we going to allow the prosecutor a la common law to freely decide where to open an investigation or not to open an investigation? We're going to bound the prosecutor a la civil law with a principle of mandatory investigation if the statutory criteria for opening an investigation were met, and the latter formula was chosen. This was a deliberate formula. That culture clash took place, a discussion took place. At the end of the day, there was some wisdom behind this, which is we want to spare the prosecutor the political discussion as to which victimization should be prioritized. If the criteria are met, the criteria are met. Gravity being perhaps the only malleable concept there. Then the exception of interest of justice was included, but you're reading it in a short fashion. It's interest of justice including the interest of victims. So the component of victimization is critical because the statute, you may not like it, but others may have reservations with that, but the statute is really victim-centered in many ways. In this sense that the statute does elaborate and depart to some extent from the technique that had been afforded, that had governed the drafting of the ICTY and ICTR basic documents. It's a much more victim-centered instrument. So the interest of justice exception was bound to be a highly exceptional exception within already from its inception. And it is not surprising that it hasn't been applied to date. It hasn't been applied to date because to date, we haven't yet encountered a situation where we can say the interest of justice, including the interest of victims, justify the exceptional step of not opening an investigation. It hasn't happened. A number of states would have loved us to approach it in a much more generous, much more political manner, and we have resisted that. And I think there are good reasons for that. The second point is that in sharp contrast, the stage of case selection is pure discretion. There are no statutory criteria there. The Office of the Prosecutor is free to move around the situation and determine which incidents to prioritize and which perpetrators to prioritize. And that's what we have done with the case selection policy. We have tried to establish criteria governing that exercise of discretion. And that, Richard, is our vision. At the end of the day, what will happen is in a typical situation, the office will identify potential cases for selection and will prioritize those cases applying the prioritization criteria. It's a fairly objective, almost mathematical at times exercise where each particular potential case is weighed due to its merits, and the pragmatic criteria for prioritization are weighed in, availability of evidence, witness security considerations, things like that, and then there will be a list of cases that becomes the prosecutorial program that we would like to achieve if we could in a given situation. So that is the vision. Now, if you were talking about more broader visions, how do we want to change the situation for good? Do we want to promote the rule of law? Well, that goes a bit beyond our mandate, I would say. I think that already is a massive challenge with the resources that we have to be able to complete our prosecutorial program per situation. And I think it is important to distinguish these levels of discretion and not to try to inject an element of discretion that really is not to be found in the statute, because every year I have the same discussion with state parties. Why are you opening a new investigation? Can you just say no? And this is, and ironically, at times the complaint comes from the same states that were vehemently opposed in Rome to the idea of prosecutorial discretion at the situation stage. So I have to get back to them and say, look, I mean, this is the system that you gave us. And surely the interest of justice is not the interest of budget. So I can't really go before a pretrial chamber and say, I would love to open this investigation. There's extensive victimization. I am a bit short on cash here. So I'm going to apply the interest of justice exception. I mean, surely that is not the system that was created in Rome. So we need to, at times, bear in mind that the Rome Statute has created a very rigid system for opening of investigations, a more malleable system for selection of cases, and it is an ambitious project. It requires an enormous amount of work, it requires an enormous amount of resources, and resources that we typically don't have. So a number of times, our own vision of what we would like to do in a situation is constrained by what we can do, realistically speaking, in that situation. And I think the same will apply to victim participation. Philip Abbach, I'm sure, will talk about this and the challenges that he faces there. The same will be in other areas like outreach, field presence, and other areas where surely we would like to honor the ambitious project that we have in the Rome Statute. At times, it becomes really, really challenging to do that. So these are my reactions only to what has been said so far. Thank you. Thanks again for a terrific panel.
Very, very much, Fabrizio. Now we've got at least 15 minutes for discussion, questions, comments over here in the back. Oh, first to Keita. Oh, excuse me. I'm sorry. Keita, go ahead, and then I'll give it to Hans. Okay, you come along. Yes.
Okay. Thank you. Just a question, not about a case selection, but a strategy selection. For some suspect or accused, arrest warrant remain under seal, and for question of efficiency, maybe the prosecutor have more chance to arrest someone. Do you think that it's the best way to arrest a head of state by inviting journalists and to announce that you will request an arrest warrant against a standing head of state? So it's not, for me, the best way to arrest the head of state. So not question of selection of cases, but question of strategy, up to OTP, of course.
Okay, thank you. Hans?
Thank you. Thank you for your very interesting comments. I have two brief observations. First of all, when it comes to case selection, I suppose that prevention would be an element that is important, because the purpose of the criminal justice system is not only to put people in jail, it is to prevent people from committing crimes. And the second observation concerns Serge Brammer's comments about the cases that remain in the former Yugoslavia. When I negotiated the agreement with Sierra Leone, the traditional chiefs wanted to see me, and I never forget that meeting. And they say, Mr. Correll, why are you coming with this court that can try only a few, when we know that there are so many out there that have committed crimes? And I thought for a moment and said, look at your own continent. Look at, for example, Nelson Mandela when he came out. Did he want everybody to be tried before a court? He installed a Truth and Reconciliation Commission. You have such a one in Sierra Leone. You have to work in combination with this, because even the most modern and well-organized criminal justice system would crumble if they were faced with so many cases on one time. So this brings me to my comment here that we have to look perhaps at a combination of solutions, because we cannot overload the ICC. The ICC has to look at the higher levels, but you may need other methods. And here is a very interesting handbook published by the Open Society Foundations called Options for Justice, a handbook for designing accountability mechanisms for grave crimes. They have studied 33 situations around the world and drawn conclusions for that, and stated a list of observations that states who consider introducing some kind of accountability mechanism, maybe on top of the ICC, should look at. So I recommend that study for further study by those who are interested here. And I will send the link to the Secretariat here so that they can spread it. Thank you.
Much, Hans. I thought we had another comment but in this section. Not? Okay. Back there in the middle. Oh, well, and then to Bill. But before Bill, the person in the back. Straight. Oh, Jim, who brought out this book, of course.
Jim Goldston with the Open Society Justice Initiative. Let me add my thanks to the panel. Great discussion. But I wanted you to complete the discussion in the following way, or invite you to do so. So Meg raised, in addition to suggesting that the prosecutor should have an explicit norm development function, she also said just you should be more candid, more open about the considerations which the prosecutor is taking into account. That the office, it would help the office achieve its aims and the court achieve its aims if the prosecutor were more open. At least that's what I understood her to say. And then, Stephen, you and Richard had a conversation which I think was in part about what should those considerations be. You were talking about whether a snack or a meal, and obviously questions there about, and you suggested, one goal is to inspire fear. One goal is to show that the court can be effective. There are goals about defending the legitimacy of the institution at a time when it is under attack. All obviously considerations that the prosecutor does and must take into account, knowing that simply the law and the evidence yields too broad a range of choices by themselves. So I guess my question is, and maybe to put it to Serge, would it be useful or not for a prosecutor to acknowledge more openly the kinds of considerations that the panel has been talking about for the public? Would that help the institution or not, if it were more open about the considerations which are very much at issue, as this panel has made clear, which people know the prosecutor must take into account, or would that not help the institution?
Jim, Bill Pace.
Well, thanks. I was going to see if I might have a question that might link this panel to the first panel on the issue of universal jurisdiction. And the question would be that if we got countries where there was actually universal jurisdiction and they weren't then forced to change their laws like Belgium, Spain, etc. So if you had situations with universal jurisdiction, is that an area where over time the international court and the national jurisdiction could assist on some of the problems that the international ICC would have in moving against all parties at one time in a situation, or moving on certain cases where because of the difficulties and the controversies, you could move at the national level in a universal jurisdiction situation?
I think we might have room for one more question. Way in the back there, if we can.
I'd like to thank the panel for the insightful contributions, and I'd like to tease out the different insights that have been offered, to ask a question and to float a suggestion. So at the beginning of the panel, Ambassador Rapp, you mentioned that Carla Del Ponte lost her mandate at the ICTR, and she lost her mandate precisely because of the question of case selection in the case of the RPF, now RPA in Rwanda. And I would also like to link that to what Prosecutor Bramett said about, and you were very open about the fact that the ICTY benefited from the political context, meaning that if there wasn't powers or a group of powers that wanted to assist the ICTY, then maybe at the end of the day, the ICTY would not have any outstanding fugitives. And I also want to link that to what Professor de Guzman said about the issue of discretion under, I suppose, Article 53 and interests of justice. What does it mean? What does it mean, the dependence of international criminal tribunals and the International Criminal Court on states? What does it mean for issues of case selection? And I think in this room we're all aware of the impressive number of non-cooperation or non-compliance judgments in the case of al-Bashir. So can the ICC be able to act outside the interests of states in the case of arrests? And with regard to what Professor de Guzman said, is it open for the prosecutor to actually acknowledge political considerations? I think that the ICC being a creature of treaty means that while the prosecutor might be aware of the need for political considerations, it's possibly not open for the OTP to openly acknowledge that perhaps we need to raise this to a different level. What if we have a discussion by perhaps the assembly of state parties on what state cooperation actually means? And there it might become more open for us to have an honest discussion, because if you look at the history of and the trajectory of the ICTY and the ICTR, cooperation was a political function, and the whole enterprise, the whole legalistic enterprise on which the ICC was built is to negate politics. So maybe the people who should be having the discussion on what state cooperation involves or implicates is not at the first instance the prosecutor, but the states themselves. Yes?
Thank you very much for your very thoughtful question in multiple parts. I think we now have about 5 minutes left. Let me go down through the panel and give them a minute or two to respond to those questions that relate to what they had said, and then that might give me a minute or two to sum up. So we'll go in the order we did earlier, and you got a specific question, Serge, to answer, but answer any of the others you wish. So go ahead.
Very quickly, in relation to the different questions, giving a press statement by saying, well, we go after person A or person B. It is obvious that communication plays a much more important role for international prosecutors than at a national level. You know, at the national level, as a prosecutor, you stay away from the media as much as you can. You do your job, and at the end of the day, you hope to have a conviction. As it has been discussed today, there are many more elements which play a role in relation to international crime. And for example, in relation to prevention, it can be very useful to make a public announcement that you will go after a certain person, after a group, hoping that it will have a preventive impact on the ground. So I'm not saying that it's necessarily the best way to announce publicly that you will put someone under arrest warrant and then hoping to arrest the person afterwards. But I think that communication must be part of an investigative or prosecutorial strategy, and you have to really use it for the purpose of what you want to achieve. Combination of solutions, I couldn't agree more. I think that what we have learned, that where probably 15 years ago we were thinking, well, the ICC is now the solution for all problems or international cases, we know the reality is that the budget is limited, the political support is limited. Well, we have to look for other solutions. And the more we think out of the box, the more we look for local solutions with international support, special advice, special expertise, a hybrid tribunal. I think we should explore every single time, the best option on the ground. Speaking publicly about the problems prosecutors have, I think we should. Because what do we see today? It is a question of consistency. You cannot have the international community on one hand saying, well, we create an international tribunal, the International Criminal Tribunal, we give you the budget, and they're not having the political support to make sure that those persons indicted are arrested. You cannot not have the Security Council sending a hot potato to the ICC in relation to a case and then not putting everything in place to have arrests secured. I think it's today really very much a question of consistency, where I personally would like to see the strong supporters of the ICC being much more vocal in expressing their support for an ICC in difficulties. Universal jurisdiction, I'm well placed to know its limitations. In the late 90s, as you know, in Belgium, we had the perfect, fully comprehensive universal jurisdiction with all the political problems we had, forced to change twice the legislation. But I also agree that if we speak about integrated solutions, well, having third countries who are in their national system prosecuting cases is very important. We had yesterday this conference in Paris on a similar topic about the national pool for investigation and prosecution of international crimes in Paris, where there are dozens of cases ongoing in relation to the Rwanda tribunal, and genocide in Rwanda, but also in relation to crimes committed in Syria and elsewhere. So I really think that there where there is not yet an international solution, there can be other options which should be explored. And you know, Michel is here from the Syria mechanism. Well, I think that by having the UN creating a mechanism which main mandate is not to have its own investigations, but mainly to collect information and to support judicial authorities. I think it's one of those new models which have an international support, but which have as primary focus to support national cases, most logically in third countries and not the countries affected. So I think there are a lot of different solutions which are currently discussed.
Meg?
We have 52 seconds, so I won't try and answer all the questions, but I do want to just say quickly, no, it's fine. Fabrizio, I'm not sure. I will look back some more at the legislative history, but my read of it is that there were very strong differences of opinion about the concepts of interest of justice and of gravity, and that they can be read broadly or narrowly, so that it doesn't really, I don't think it's really fair to say that the statute ties the prosecutor's hands in the way that you would like it to, but we can continue that debate. I think that Hans Krell's point about prevention being the key is also, for me, the answer to Jim's question about how much should the prosecutor communicate. I actually think that being more candid is more likely to lead to prevention in this context where the goals remain under development, and that being more candid enables a kind of dialogue with supporters of the court, with the global community, where the goals can develop in more and more fine-tuned detail, and over time the prosecutor will have more to work with in that regard. So I think being more candid is actually really important.
Thank you very much, Meg. Richard?
Okay. We're in overtime, so I'll try to be quick. On this issue of discretion and the questions that were raised, I would advise strongly against the prosecutor acknowledging political factors that go into a decision she makes. Once that happens, then it's opening a Pandora's box. So I would strongly be concerned about that. At the same time, I would like to hear more from the prosecutor about the problems she is facing in terms of the resource challenges, in terms of the need for states, parties, and others to contribute to and make arrests possible. I'm thinking of Luis Arbor, I'm thinking of Carla Del Ponte, I'm thinking of Serge Bramertz in terms of making the need for arrest very visible. That said, I don't necessarily think, Keita, that getting up and announcing an arrest warrant against a head of state is necessarily the best way to proceed. And again, I'm thinking about the work that Luis Arbor did in terms of ushering in sealed indictments against accused or suspects that helped facilitate their apprehension. So I would be wary about making an announcement for the sake of getting on the evening news.
Okay, well, we've come to the end of it. I was to sum up, I think it's difficult to completely synthesize because we've had a lot of different views expressed. But let me just say one thing to lead off, and it was a point that Richard had made at the beginning. And as we commemorate the 20th anniversary of the Rome Statute and 15 years of operation of the ICC, is how important this institution is to the world, and how all of us need to work in our own societies, in the coalition groups, and everywhere to build the support that it needs to enforce these norms. It's really the hope of humankind for a system, for a world in which these crimes are not committed to the extent that they are today. And with 68.5 million people in refuge, either across borders or outside their homes in their own countries, which is a record since World War II, We know that these crimes are occurring, that they're expanding. We deal with South Sudan, Myanmar, Syria, elsewhere, and making a more effective system of holding people to account is, I think, absolutely necessary. That'll take more resources. I think it does lead us into this issue and this point that I think Meg made, and it's something you hear from Ben Ferenz every time he talks, because he's such a believer in the idea of deterrence, and that is that in the way the prosecutor selects cases, in the way that she or he describes the strategy, it's important to note that one's looking for the maximum impact, trying to prevent others from becoming victims of genocide, war crimes, crimes against humanity, rape, murder, torture, and other horrendous acts, and recognizing that in some situations you can make progress and have an impact, in others you can't. In some cases you don't have the strong evidence, in some cases you can't protect the witnesses. These are all practical factors that need to be respectfully acknowledged as the cases are put forward. And we certainly appreciate the policy statement of the prosecutor from 2 years ago, and what the prosecutor was saying today, and particularly on this arrest issue, the efforts that she wants to make to further and to get cooperation of states on transfers and arrests is, I think, an indication that things are moving in a very positive direction. And so let's thank the panel and take a few minutes break and come on back. Thank you.